Bismillahirrahmanirrahim. Peace and blessings. Assalamu alaikum. Welcome everyone to our Estate Planning for Muslims webinar with attorney Todd Gallinger. This presentation represents the views of attorney Todd Gallinger and not necessarily the views of the Islamic Center of Southern California. Please make sure to write down your questions in the question and answer chat box below. It is my honor to introduce attorney Todd Gallinger. As an attorney since 2005, Brother Todd has assisted businesses, individuals, and nonprofits with complex legal matters. Furthermore, he brings a wealth of experience as a nonprofit leader, strategic advisor, licensing expert, and active member of various boards. Brother Todd holds a Bachelor of Arts degree in Religious Studies from the University of California at Santa Barbara, a Juris Doctorate in Law with honors from the George Washington University Law School, and a Master's of Arts degree in Islamic Studies and Leadership from Bayan Islamic Graduate School. With his extensive expertise, Brother Todd has a deep understanding of the various legal issues and challenges that Muslim nonprofits encounter. This allows him to proficiently create highly effective and customized legal solutions, particularly in the areas of estate planning and nonprofit law. So please welcome Brother Todd Gallinger.
Great. Thank you so much, Erica. And it's so good to be here with the Islamic Center of Southern California. Definitely a hallmark in our community. So yeah, glad to share some information, and hopefully too, if people do have questions, they can type those in the Q&A box, and then those can get filtered through the moderator. Definitely, if I've missed anything, if there's something that you feel is really important, please let us know so I can try to cover that. Do want to talk about, and hopefully we can all spend some time thinking about, how we apply the Islamic tradition in America, in our position as American Muslims, and in my expertise as a lawyer, I'm really talking and thinking about in the legal field, how do we apply, make it so in a legal way we can do the things that the Muslim Islamic tradition tells us that we ought to be doing. Work with different individuals and institutions to accomplish that in different ways. And there's up on the screen right now some of the areas and things that people could bring in their Islamic tradition and incorporate that into the legal decisions, legal documents, things that they're doing, here in America. Mainly going to be talking about on the top there, estate planning, but do want to recognize and mention, of course, there's other areas as it pertains to Islamic law and Islamic legal tradition. So as we look at estate planning, it's not the easiest thing to talk about and to think about. We're talking about, what do we do when we die? But it is an essential. It is something that everybody has to deal with, has to work through. The most basic estate planning document that we might talk about is what we call a will. And this is a document that tells people what you want done with both your body and your stuff when you die. I want, a certain set of religious traditions, a burial at a certain spot. And then also, here's the things that I've accumulated during my life. Here's what we can do with them to best represent my values, best to preserve that going forward, have a sense of legacy as it comes to our lives and the things that we've accumulated. One of the really important things to do in a will is appoint who you would want to be the executor, the person who's in charge, and all these different things, kind of the person that you're empowering to make the decisions to follow through on your wishes is really important. And I'd recommend that you spend time thinking about that. As it comes to who should be engaged in this, who should think about these issues and take these steps, really everybody should have a and there is a hadith from Bukhari that talks about the Prophet, peace be upon him, saying that any Muslim who owns any property, should create a will if they own that property for at least 2 nights. It's for us to think about too, as we'll talk about, the traditional Islamic inheritance structure is divided into 2. There's a part that's voluntary, which they call the wasiyah, and there's a part that goes to your family according to a Quranic structure. That's called the mawarith in Arabic. Prophet Muhammad, peace be upon him, is only talking about the wasiyah, only talking about the voluntary part, because, and the Islamic, the Muslim countries under Prophet Muhammad and others, the Islamic rules would be followed anyways. In our circumstance, like, as everybody's probably aware, unless you elect to follow the Islamic rules, follow the Muslim tradition in a legal way, that's not going to be what the default laws do. So I think it would probably be more important for us here to think about these issues and how we bring the Islamic tradition into our present context. So a will is good. Everybody should have it, but we live in a complex legal society. And a will is really not enough for most people or a lot of people if they have sufficient property. The way that it works, if you have property over a certain amount and you pass away, even if you have a will, the court says we want to make sure that stuff's done fair, so we're going to supervise it and we're going to oversee the process through what's called the probate court. And that might be, sound good to some people, but unfortunately, the court system is very broken, really inefficient, and this can cost, an average family maybe tens of thousands of dollars. In certain cases, it can, really deplete the entire value that somebody's leaving behind. Court cases take a long time. Minimum that it's probably ever going to go is about 6 months. I just got paid on a case I stopped working on in 2012. It's 2024. I think it was last month, January of 2024, a case that I worked on 2010 to 2012. Another lawyer picked it up after me, finally got closed. And so that case took about 14 years for the family to be able to close it out and have full value of the assets that the person left behind, at least in theory. All the stuff actually got eaten up by the court process in that circumstance. And going through probate is expensive. It charges a certain percentage of the property that they're going to take a look at. If you elect to have your own person do it, the trustee, there isn't a set fee like that. If there's a problem, if the trustee, the person that you appointed, doesn't do what they're supposed to do, the people that you've said should get the stuff, your beneficiaries, can take the case to court. They can make what you've said and done enforceable through a court of law, but you're taking the steps to avoid going to the court unnecessarily, to avoid, again, tens of thousands of dollars, a lengthy public court process, and not putting your family through that. That was already one of the hardest times for them. If your estate is going to go through probate, changes from state to state. Here in California presently, it's about if you own a little bit more than $100,000 in total property or $60,000 in real estate. These amounts do change based on inflation. So these are, approximate numbers for 2024. Note on that value of real estate that it's total value of the real estate, not your equity. So if you have a home worth $500,000 and you have a $600,000 loan against it, it still counts. It's still going to be subject to probate. It's hard to imagine any real estate in California right now worth less than $60,000. So almost everybody who owns any real estate wants to create a trust, wants to put that property under the trust so that when the inevitable happens, their families can avoid those difficulties and expenses. The way to do that is by creating what's known as a living trust. This, from a legal perspective, is called a revocable trust. It's revocable because you can cancel it, you can change it, you can put stuff into it, you can take stuff out of it. So you're really not tying your hands in any way as it comes to the property that you would put under a living trust. Because you can still access it, because for all intents and purposes, it's still yours. If you create a living trust, you aren't going to get any sort of tax benefits or any asset protection benefits. Again, the property's really yours during life. It's just the probate court that's going to say, okay, this house was owned by the trust, so it doesn't need to come to us. It can pass through this alternate method. For not everybody is the revocable trust enough. Some people, if they want to put in place certain kinds of tax protections, or there might be other circumstances, they can create what's called an irrevocable, a non-revocable, non-cancelable trust. This is generally a more expensive and difficult, and something that you want to think about more thoroughly, because once you do it, once you transfer the property there, it's not your property anymore, and you can't get it back. So this could be set up for charitable reasons, but also for, certain circumstances for tax benefits. A lot of times, if somebody's having a major business transaction, doing some things in this area could potentially save them on taxes and allow them to give a greater donation to, a charitable institution. Another circumstance that it does come up often is if somebody is receiving benefits and they need to keep their amount of property that they own under a certain amount and keep receiving those benefits. And a lot of times, if there's a legal settlement as a result of a tragic accident or something like that, those funds might go into what's called a special needs trust, so that they're protected. They can be used for the person's benefit if they need them, but the person also won't lose their health coverage or other benefits. This is a super complex area, mainly going to be applied by people who have a special need if there is some special circumstance that comes up, or we're really talking about estates over $5 million, I think. So now we get to the fun part, the Muslim part. All of that stuff is things that applies to everybody. So everybody in the US really should take those steps. Everybody in California, according to the rules that I laid out, should take those steps to protect their family, protect their estates, make sure that things transfer in an efficient way, that we're able to preserve your wealth for your family and the community's benefit, versus it going to the state, to taxes and administrative fees or the courts, something like that. So some of us may remember, maybe a 10, 12 decade ago, 12 years ago, there was a whole series of what they called Sharia bans going through the states, where different states, some of them actually passed bills that said U.S. courts won't enforce any aspect of Sharia law, whatever that might mean. Those were all struck down as unconstitutional. The idea that there's any conflict between doing stuff as Muslims, trying to, just like anybody else of any religion does, trying to put those aspects of the Islamic tradition into legal documents, incorporate them into your life in meaningful ways. It's very protected by the First Amendment. We're blessed. The United States does have some of the broadest, perhaps the broadest religious protections in the world, and Muslims are able to thrive. Muslim communities are able to grow because of that. Muslims are especially able to do this in the area of estate planning. The cases that challenged those state-level Sharia law bans actually did involve estate plans, did involve an individual in Oklahoma who had created a living trust according to the Islamic tradition. And the Circuit Court of Appeals at the federal level said, yeah, you can do that, that law is unconstitutional, and we're going to block it from coming into place. It had been quiet on that aspect for a while. I'm sad to say, I think, actually recently, because of the tragedies in Palestine, the ongoing humanitarian crisis, some of the anti-Muslim, the Islamophobic people that push some of those laws are popping back up and saying things about the community and activism. But, we should be able to be confident that we have those legal protections. What I would kind of think about it is, what we're taking and we're doing is we're taking the Islamic tradition, our understanding of it, we're putting it in the four corners of an American legal document. We're following all the rules as it comes to creating a California legal will or California trust. But as it comes to filling in the person's wishes, we're going to put in the Islamic rules. So yeah. What are those Islamic rules? So as I mentioned, in the Islamic tradition, generally the inheritance can be, the rules about what we do with our property when we pass can be understood as being broken up into two different broad areas. One that's called wasiya is you can do almost whatever you want. That this is your charitable, and up to 1/3 of your estate. And that could be given to an institution, to the mosque, or under most schools, it could also be given to if there was a family member who would inherit from you under the mandatory structures. It generally can be given freely up to the individual, but again, it is limited to 1/3 of the total estate. Note that within the Islamic tradition, within the Islamic legal tradition, fiqh, there is no restrictions on any sort of lifetime gifts. And so the 1/3 can be freely given at the time of death. According to the Islamic legal tradition, 5 minutes before death, the entirety can be given away. So that restriction on charitable giving just applies to what is owned when somebody dies, doesn't apply to what somebody chooses to give during their life. After somebody has given, after the voluntary gift has been, charitable gift has been given out of somebody's estate, then according to the Islamic legal tradition, their family is entitled to the rest. And there is a structure that's laid out in the Quran. You can see the verses there. I encourage anybody who's interested to pull up those verses, read through them, think through some of the different situations that might come up, how those might work out. It's a good exercise to get some understanding of what Islamic legal scholars may do. We do need the work and the tradition that scholars have given us. Simply looking at the Quran does not clearly answer every question that comes up for every family. And so there is the need to study and to review the rich Islamic history, the rich scholarship that's there as it relates to these issues through all the different schools, all the different madhabs. The family structure is also can be thought of as divided into two. There's one group of relatives who get to set share. For most people, that's going to be their spouse and their parents. And then once that set share is given, then the remainder, what's left over, is normally given to people's children. There is a difference here in the Sunni schools and the Shia, the Jafari legal school. If somebody has one daughter, the ability of that one daughter to inherit a full share. That's an issue that does come up, particularly in societies where there's big Shia and Sunni communities, such as Lebanon and Iraq. And there's actually stories in court cases about people switching sides because they want to take advantage of those rules. So that's one area that shows, where different scholars from different schools have reached different conclusions, all looking at the Quran, all interpreting it. Some other issues that do come up, some common questions as we work through these issues. One is the wills and the trusts. Those only come into play if somebody passes away. If somebody's anything but dead, those documents don't have any legal power. So a lot of people do also create advanced healthcare directives and durable powers of attorney to address circumstances of long-term disability. If somebody's still living, but not able to make their own decisions. A very common question that comes up as it pertains to advanced healthcare directives. Other states outside of California, sometimes called living wills. And these are, we're going to give our healthcare instructions, say who we trust to make those decisions for us, also give them the guidelines that we want them to follow. The biggest issue addressed by most people comes down to end-of-life care, to extend it or not, to quote-unquote pull the plug. And the question is, if doctors can only do that if they really determine that there's no chance of the person recovering fully. And if the doctors have decided there's no chance of recovering fully, do we want to artificially extend life? And not recover fully, but recover meaningfully, recover and have any meaningful quality of life. Do you want to continue to artificially extend life in that circumstance? Miracles do happen. Doctors don't know everything. Or is it the decision to not artificially continue life, to quote unquote pull the plug? For a lot of people feel preserving dignity, perhaps, protecting family assets, not wanting family to suffer anymore. Neither one am I advocating in this circumstance. It is the vast majority of current scholars agree that Muslims can choose between those two options. Though euthanasia, there's a strong ban on doing anything that might further somebody reaching the end of their life. That's clearly forbidden in every school of Islamic law. That's not what's happening if you choose to continue, or choose rather to discontinue means of artificially extending life. Another very common issue that comes up pretty much every circumstance is understanding the difference between California community property and then, how that works versus separate property. Everybody in California is going to have community property unless they've explicitly decided to do something else. Unless they've explicitly said normally separate property is the way that it's kept track of. That is different than the Islamic legal tradition. I would say both of those, and maybe have some little discussion why. Both of those, both the California community property structure as well as the separate property structure that many other states use, are both different from the way a married couple would own property in the Islamic legal tradition. Under the Islamic legal tradition, distribution happens when a person dies and their spouse gets a share, meaning that the surviving spouse in a couple, if the Islamic legal tradition is strictly followed, may not be able to have all of those assets available to them. That might put some people in difficult circumstances. So that is an issue that Muslim families here confront, and something that we talk about and try to work through. Another issue, very common issue that comes up, is people having questions about the different distributions between sons and daughters. It also comes in place for husbands and wives, but not for fathers and mothers. Fathers and mothers do inherit equally, but sons will inherit twice the share of daughters. Perhaps the reason why, or there's understanding that the reason why, is in the Islamic legal tradition, a male would not own property outright. It's very clear in the Quran and other sources, a woman owns her property completely. No man or no other person has any claim on that. A man, however, does not own his property. A man, it could be said in the Islamic legal tradition, owns his property in trust for his close family members. And they could, in a theoretical circumstance, take him to court to get supported. So, if theoretically I have two sons and a daughter, I follow this tradition, my son gets twice the share, my daughter doesn't need to spend her share on her basic support. My son is supposed to spend from his share to support her, and then she has her share freely, however she wants to use it. That isn't how the legal system works here in America. There isn't a difference in, how property owned by a man and a woman is treated in the legal system in America. So, there are some circumstances and issues to think through there. The way I approach this, my position on all of this, I'm an American lawyer, and as was mentioned, I have an academic background in this area. I'm not a sheikh, I'm not mufti, not my job to tell anybody what's right or wrong. I don't know that anybody knows what's right or wrong for other people, or at least I'm not in a position to pass judgment. I think these are interesting and sometimes difficult issues that every American Muslim really has to work through in one way or another. That could be by approaching a traditional scholar and asking them for their advice and following that. It's a very valid way to approach it, but I am not that traditional scholar. So I can share from academic knowledge. I can tell you this is what the Islamic legal tradition did. If people have questions about a specific school and a specific time, you could do the research and answer those. But I can't say within a religious context, this is the right or wrong thing to do. So, and I'm happy to see if we have any questions. And I've got a couple in the chat there. And so the first question that I see is, what are the set shares for spouse and for parents? So for parents, each parent will take a sixth, both mother and father. If then living, when somebody passes, will take a sixth. And then for the spouse, a husband will take a quarter and a wife will take an eighth of the estate. So one thing to mention too, when we're talking about the estate in California, it's generally going to be 50% of everything owned by the husband and wife together, because like I said, we have community property. This sometimes can be confusing and scary because people think, oh, I have to sell the house, like I have to give out 50% of the house. Think about the stuff overall. I advise families to think about all of the property together overall. If there's a car worth $20,000, that can all be given to one person. The car doesn't have to be sold and then 20% be given to each person who's entitled to 20% of the overall estate. These are issues that can be handled would be handled by the trustee, the person that you've appointed. Um, Advice on coming to that, it does help to have somebody who understands financial issues, but by no means do they have to be an expert. By no means they have to be an accountant or a lawyer. You can hire those people. You can't hire somebody who knows your values, so think through somebody who you would trust if a difficult family circumstance comes up. Who would you approach for guidance, and who have you discussed those issues with? Who would know what your wishes were? So I do have a question about the session being recorded and shared, and I think it will be. Erica can let me know if I'm wrong, and I'm happy to share the slides as well too.
Yeah, so this webinar is being live streamed onto our YouTube channel and our Facebook page. So if you want to rewatch it, or for the people who didn't have a chance to watch it this evening, you can always go back to our YouTube channel and watch it, or our Facebook page.
Good. Yes. So hopefully people can find the way to check it out there as well, on the Facebook and YouTube for the Islamic Center of Southern California. Another question came in: can a male and female child agree to split their inheritance equally? And yes, they could. In the Islamic legal tradition, majority of scholars would say they can't make that decision ahead of time, that people can't voluntarily give up a share before the person who would give them the share has passed away. That they could make that decision at that time, and technically it would be the son gifting it to the daughter. It could be expressed that way as wishes. It could be discussed that way with family. But yeah, they could certainly agree to do that. Similarly, children could choose to give up a share that would go to one of their parents. So if the traditional Islamic structure was being followed, and when the first spouse passed away, and the majority of that person's share of community property is going to the children could say, we don't need that right now, but I think mom or dad might, that would be better for them, and could voluntarily give up those gifts at that point. But again, according to the majority of present scholars, they couldn't make that decision ahead of time.
There's still a couple more questions that are coming in.
Okay, good. So I see another question about, do we have to have a will or a living trust, or either one? And yeah, that depends on your financial situation for the most part. I mean, I would advise everybody to have a will, to think through those issues. If you don't have a will, then you die what's called intestate. And the law of the California says, this is how to divide my stuff. Go and look it up to see if that's what you want. In most cases, it's not. In most cases, you probably got some thoughts about it. So you want to put those down and capture those in a will. Everybody who has any property should have that. In California, if you own real estate or $100,000, $180,000 in property approximately, then you also want to have a living trust. That would be my advice as an attorney. The reason being is that estates valued over that amount would be subject to probate, have to go through the court process. At the end of the day, it's going to cost your family a lot more than to create the living trust. A good question, and a very common one, comes up about when real estate is in joint title. So a husband and wife own real estate as joint tenants. Maybe they own it as community property with rights of survivorship, husband and wife as community property. There's a few different ways it could be formally written as a title. And it wouldn't have to be even a husband and wife. Other people can own property jointly. If you own property with somebody as joint tenants, if there's two people on the title, when one dies, the other one owns it 100%. But we don't look at party one's will. We don't look at their trust. We don't look at anything. Just when they die, the survivor owns it 100%. So many married couples buy property, own it as joint tenants. That's the normal way of taking it if you don't have a trust set up. When the first person dies, that estate will not be subject to probate for the reasons of the real estate. If it's in joint tenancy, again, the real estate now belongs 100% to the survivor. So the real estate doesn't have to go through probate. If the person had more than $180,000 in other property, that might have to go through probate. But the issue is eventually the surviving spouse is going to die. Eventually we all die. So having the issue or having the title in joint tenants, it doesn't really take care of the issue. Eventually, you'll want to transfer that under a trust, make sure that the things are transferred to family in the way that's efficient, in the way that preserves wealth, that allows that to go towards the values and the things that you've chosen. And so, you're going to want to create the trust. The worst can happen. Things can happen to people at the same time too. And so if that does happen and people own it jointly, now it goes to probate and the family has to go through that. Questions about using websites to help with Islamic wills, or there's websites that are out there that you can create living trust wills, other things as well. I would not advise using them. It's an area that understanding the choices that you're making can be difficult. And so it's easy to click a button on a website. It might take a lot more understanding to know what are the consequences of clicking that button. Additionally, creating a trust, you have to make sure that it's properly funded, that the property that you own is properly transferred to it. If it's not, the trust has no impact. And doing the stuff on a website doesn't take care of that process. You have to follow up and do it yourself. Most people don't understand that and do that anyways. I do think it's an area that it's worthwhile to consult an attorney on, especially if you are looking for to incorporate the Islamic legal tradition or something else that falls outside of the American legal tradition. Most courts and situations would be prepared to deal with. So a question about guidelines for property owned before marriage. And so property that you take into a marriage is not community property. Similarly, property that is received by a gift, including a gift from inheritance, is not community property. So if I'm married and one of my parents passes away, they give me a house, my spouse does not get a share of that house. My spouse does not get a share of the property that I have received as a gift or an inheritance unless I choose to give it to them. I can gift it to them. I could put both of our names on the title. I could put that money in a joint bank account. All of those things would probably be evidence that I wanted to share it with my spouse. But if I either receive a gift or if I give a gift to my child, through my will or trust, their spouse doesn't automatically get that. It's automatically by default considered to be separate property, not community property. But again, either gifting it intentionally or mixing it together, commingling it, could change the nature of it and make it community property. Did I miss any there, Fiddy or Erica?
I think you're on mute, Sister Fiddy. Yeah, there you go.
I don't know if this is the place to answer, but someone was asking what the cost should be to draw up a living trust.
Yeah, and so it does vary per family, depending upon exactly, how much property you have, the other issues that come. For most families at my law firm, it ends up being $3,500 to $4,500. For a family that owns real estate, that's going to be creating a living trust and wills along with it. If the person creates a trust, they also need the wills to go along with it. Question I see as well too, one that I said that I did miss, to pertain to guardianship over minor children, and that is an issue that you would specify in the wills. The trust is only a financial instrument. It only deals with money. It doesn't deal with your body. It doesn't deal with your kids. Doesn't deal with anything else beyond the money that you transferred into it. You can put in your will, or you could write in other documents as well too, who you wish to be the caretakers of your minor children if something should happen to you. Be aware that simply writing it doesn't 100% guarantee that that's going to happen. The courts do always maintain jurisdiction, quote, quote, in the best interest of the child. That's the rubric that the American legal system operates under. So if that person that you've assigned, something has happened to them, they're not there, they're hospitalized for some reason and unable, the court could say, no, somebody else is better, but 99.99% of the time, right, unless there's a really, really good reason, they're going to follow the specified wishes of the parent. and the will would be the right place to do that. So some questions about the sequencing of wills and trusts. I think it's different in each circumstance, so can't really answer that generally. If you've already purchased real estate, then you're going to want to create a trust, or the legal advice would be to create a trust and then transfer it under that trust. If you buy new real estate, you can buy it directly under the trust. You could give the escrow agent, that's how real estate is purchased generally here in California. You could give them the name, your names as trustees of the trust is how it would be formally structured. They just put that on the deed right away. Banks, other institutions, very used to dealing with living trusts. And so transferring your property to a living trust won't create any problems with the mortgage. It also, here in California, is a Prop 13 exempt transaction, meaning that it won't have any changes in the underlying real estate taxes. That it'll be, it's also exempt from most of the deed filing fees. Not all of them. It's about $100 to $150 per deed that you have to pay here in California. And a question about, is there any specific structure or format we should follow? And again, no, I would say it kind of depends on each family's individual circumstance. Certainly I have template documents that I use. I've talked to a family, an intake form to figure out what what their property looks like, what assets they own, what their family structure is, what their wishes are. Based upon those different things, I pick out which amongst the templates that I have I'm going to use. So I don't know that you could figure it out right ahead of time. Children can be added to a trust. So they're normally there. So understand within a trust, there's a few different roles. Just go through them real quickly. One that we're always thinking about is the beneficiaries. That's the people who get the benefit of it. In a living trust, that's going to be the people who get your property when you die. So a living trust, it's called that because it lives with you. And then when you die, the trust dies too. The job of the trustee is to get rid of the property of the trust, give it to your children, other beneficiaries that you've assigned. That could be the masjid, could be another charity, if you're electing to do that with your wasiya, to give that property out. And for most people, the children are, that primary place that it's going to end up. You can also assign your children to be trustee. So in a trust, we're breaking up the benefit of the property and then the control of the property. The trustee is the person who's in control of it. The beneficiary is the person who gets the benefit of it. You can also assign your children to be the trustee. The person who's the trustee can also be the beneficiary. While you're living in a living trust, you're in both roles. You're the beneficiary during your life, and you're in charge of all the decisions. You can assign your children to be the trustee, to be the ones who make that decisions. Every family is different. And so, that issue is one that I a lot of times talk through with clients, who would be the best in your family, in your circumstance. Sometimes people feel that would be the children. Other times people think that might create a conflict between their kids. And so they'd rather pick a close family friend or an elder family member, something like that. All legitimate decisions and ones I think for each family to take a look at and try to work through.
Wonderful. Thank you so much, Brother Todd. And hopefully everyone understands the seriousness of taking care of their wills and trusts. And inshallah, when you do that, you protect your family and your future, and also consider leaving something for our Islamic Center.
Yeah, thank you very much, Todd Gallinger. And Sister Jihan, did you have any questions that you want to
No, I wanted to thank everyone on the panel for a great job and dedication. And I wanted to mention something else. A living trust really is a protection for the entire family and your generations to come.
Yeah, no, I think it is an important thing. Again, not everybody needs a living trust. If you're blessed where you own real estate, you have sufficient property, alhamdulillah, it's the smart thing to do. Not all of us are in that circumstance. So I think everybody, though, should think about these issues. It is the inevitable. It is something we have to deal with. It's something many people have in the back of their minds for years before they take steps. A lot of times they may take those steps because something tragic happens and that triggers it. I would encourage you not to find yourself in that circumstance because, like I mentioned, I had a 14-year case for family members, for community members that I had worked on, and that you don't want your family members to go through that. So think about it, and hopefully it's the information is helpful. Thank you so much to the Islamic Center and to everybody else for tuning in.
Thank you very much, Attorney Todd Gallinger, for this enlightening webinar. And I want to also thank our panelists from our development committee for joining us this evening. And I also want to thank our audience, and may Allah bless all of you. Assalamu alaikum. Good night.